He was born in Memphis, Tennessee, where he was the youngest of 5 children, and his parents were Orthodox Jews. He acquired a lifelong love for music from his father, who encouraged his playing of the violin. He was known around town as Fiddlin' Abe Fortas. He attended Rhodes College in 1930, but eventually transferred over to Yale Law School, where he became editor-in-chief of the Yale Law Journal and graduated second of his class in 1933. After graduation, he became a professor of law at Yale for a short period of time before he left to run the U.S. Securities and Exchange Commission. Around this time, he met Caroline E. Agar, a successful tax lawyer, and he married her in 1935. They never had any children. He served as the General Counsel of the Public Works Administration and as Undersecretary of the Interior during the presidency of Franklin D. Roosevelt. It was during this time that he met a young congressman from Texas named Lyndon Johnson. In 1945, Fortas joined the armed forces. However, he fell ill with a case of tuberculosis and was discharged within a month. In late 1945, he was appointed by President Truman as an advisor to the U.S. delegation during the organizational meeting of the United Nations in San Francisco and at the 1946 General Assembly. In 1946, Fortas founded the law firm Arnold & Fortas with Thurman Arnold. They established one of Washington's most influential law firms. In one case, Fortas defended Lyndon Johnson when his name was removed from the general election ballot due to allegations of corruption in the voting process. Fortas persuaded the Supreme Court justice to overturn the ruling, and Johnson won the election and became senator. Two other popular cases include Durham v. the United States and Gideon v. Wainwright. In 1953, Monty Durham's insanity defense had been rejected at a lower court trial due to the imnegation rules, which required that the defense prove the accused did not know the difference between right and wrong for an insanity plea to be accepted. Fortas represented him before the Court of Appeals, and the court accepted his call to abandon the imnegation rule and instead to allow for testimony and evidence regarding the defendant's mental state. In 1963, Fortas represented Clarence Earl Gideon in his appeal before the Supreme Court. Gideon had been convicted of breaking into a pool hall. Since he was poor, he could not afford a lawyer, and none was provided when he asked for one at trial. The Supreme Court ruled that the states are required under the Sixth Amendment to provide counsel in criminal cases for defendants unable to afford their own attorneys. In 1965, President Johnson persuaded Supreme Court Justice Arthur Goldberg to resign his seat because he wanted Fortas to replace it. Johnson thought that some of his reforms of the Great Society could be ruled unconstitutional by the court, and he knew that Fortas would let him know if that happened. Fortas formed good relationships with the other justices on the court, although some of them worried about his close relationship with President Johnson. Ford did clash with one associate justice, Hugo Black. They argued about the manner in which the Constitution should be interpreted and found themselves on opposing sides of the court's opinions. In 1967, the case of Fortson v. Morris allowed the Georgia state legislature to choose the governor of Georgia in the deadlocked Georgia gubernatorial election of 1966. Fortas said that the state constitution of 1824 was at odds with the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. However, Justice Black took the strict constructionist view that the U.S. Constitution does not dictate how a state must choose its governor. During his time on the court, Fortas extended the due process rights and the procedure to legal minors and overturned the existing paradigm of parent of the nation in which the state had parental control. The case of Kent v. the United States was the first Supreme Court case that evaluated a juvenile court procedure. Fortas resigned from the court in 1969 when his reputation was ruined because he accepted several thousands of dollars in money from families on Wall Street and from universities.